Hermione explains private international law. Part 2, the courtroom maze, how courts decide between competing legal systems. Welcome back. Last time we followed people across borders. We talked about identity, nationality, domicile, personal law, children, marriage, status. But now we have reached the point where all those human problems arrive at a courtroom door. And the court faces a problem, not a human problem, a legal problem, because by the time a appeal dispute reaches court, multiple legal systems may already be claiming authority, and the judge must somehow untangle the mess. This is where Module 4 begins. Rules for choice of law. Imagine a judge opens a file. Inside is a dispute involving an Indian citizen, a marriage in Singapore, property in Dubai, a divorce petition in England. At this point, the judge is not deciding who is right. The judge is asking something more fundamental. Which legal system gets to decide who is right? That question lies at the heart of rules for choice of law. Think of choice of law as the legal equivalent of selecting the rule book before the game begins. Before anyone can win or lose, the court must know which law governs the dispute, because different legal systems may produce completely different outcomes. The same facts, different laws, different results. Hermione's shortcut foreign element. Choice of law problem. Select governing law. Decide dispute. This sounds simple. It is not, because before choosing the law, the court must first answer another question. Chapter 2. Characterization. The topic that secretly controls everything. Imagine somebody hands you a legal dispute. The judge immediately asks, what kind of dispute is this? Contract, tort, family law, property, succession, trust, marriage? The answer matters enormously because different categories use different choice of law rules. This process is called characterization, also known as classification or qualification. Many students treat characterization as a minor topic. It is not. It is actually the first intellectual step in conflict of laws, because the court cannot choose the correct law until it knows what kind of dispute it is dealing with. Think of a hospital. A doctor does not begin treatment immediately. The patient is first assessed, classified, diagnosed. Only then does treatment begin. Characterization performs the same function. Characterize, classify, choose law, resolve dispute. Without characterization, choice of law collapses. Chapter 3, how lawyers accidentally invented legal ping-pong. Now we arrive at one of the most famous headaches in all of private international law. Renvoi. The word itself sounds intimidating. The idea is worse. Imagine an Indian court decides French law should apply. Wonderful, problem solved. Except it isn't. Because when the court examines French law says, actually, this matter should be governed by Indian law. And suddenly the dispute has bounced back, like a tennis ball. This is renvoi, a referral problem created when legal systems point toward each other. The first route, remission French law, points back Indian law. This return referral is called remission. The second route, transmission French law, points elsewhere, German law. This referral to a third country is called transmission. And now 3 legal systems are involved. The headache grows. Double renvoi, the theory that refuses to leave. Some courts go further. They ask, what would the foreign court itself do? Instead of stopping early, the foreign court attempts to imitate the foreign court's entire conflict of laws process. This is called double renvoi, total renvoi. Hermione's memory trigger renvoi, legal ping-pong, remission, bounce bands mission, bounce forward, double renvoi, become the foreign judge. Chapter 4, content of juridical law, the strange rule that surprises everyone. Now assume the court has finally selected foreign law. A new problem appears. How does the judge know what that foreign law actually says? Many students assume the judge will simply look it up. Not usually, because foreign law is treated differently. Have the golden Indian rule. Foreign law equals question of fact, not question of law. This means the court does not automatically know foreign law. The parties must prove it. Imagine an Indian court applying French law. The judge is not expected to be an expert in French legal doctrine. Someone must explain it. Someone must prove it, usually through expert witnesses, legal scholars, official documents. specialized legal evidence statutory anchor historically associated with Section 45 Indian Evidence Act 1872 and today reflected in Sector 39 Bharatiya Sakshya Adhiniyam 2023 regarding expert opinions, Hermione's Formula Foreign Law Question of Fact, Expert Evidence Law. Chapter 5, Arbitration, the Alternative Path. Now suppose the parties decide we don't want a traditional courtroom. What then? They may choose arbitration. Arbitration is essentially private dispute resolution. Instead of judges, parties select arbitrators. Instead of ordinary litigation, disputes proceed through arbitral mechanisms. The most important idea here is party autonomy, because the parties themselves often choose which arbitrator, which country, which procedural rules, which governing law. At the end comes the arbitral award, which courts may later recognise and enforce. Hermione's Formula Agreement, Arbitration, Award, Enforcement. Chapter 6, Recognition and Enforcement. Winning is not enough. Imagine you win a case. Wonderful. Except your opponent's assets are in another country. Now another question appears. Will that country respect your judgment? This leads to recognition and enforcement. Recognition means the foreign judgment is accepted as legally valid. Enforcement means the judgment is actually given practical effect, money recovered, orders implemented, rights protected. But recognition is not automatic. Courts perform checks, and one of the most important checks is #public policy. If a foreign judgment seriously violates fundamental principles of justice, the court may refuse recognition. Hermione's Formula Foreign Judgment, Recognition Test, Public Policy Check, Enforcement. Chapter 7, Can a Corporation Travel? The Recognition of Foreign Legal Persons. Now we reach the final topic, a surprisingly philosophical one. Human beings can cross borders, but can corporations, can companies, can legal entities? Suppose a corporation is validly incorporated abroad. Can it sue in India? Can it own property? Can it enter contracts? Can it enforce rights? To answer these questions, courts must determine whether the foreign entity possesses legal personality. This topic is called legal recognition of foreign legal persons. Key terms: juristic person, corporate personality, corporate capacity, legal entity. Think of it this way: a corporation has no body, no mind, no physical existence. The law creates it, and therefore another legal system must decide whether it will recognize that creation. Hermione's Formula Foreign Corporation, Recognition, Legal Personality, Corporate Capacity. The grand reveal noticed something fascinating. Module 3 focused on people, identity, status, family, children, marriage. Module 4 focuses on courts, classification, choice of law, recognition, enforcement, procedure. Together they form a complete Peel journey. A person crosses a border, a legal dispute arises. A court identifies the person's legal connections. The court characterizes the dispute. The court chooses the governing law. The court resolves referral problems. Foreign law is proved. The dispute may go to arbitration. A judgment or award is delivered. Recognition and enforcement follow. Rights become effective across borders. Hermione's end of lecture summary: nationality and domicile, personal law, status, children and welfare, marriage and matrimonial issues, choice of law, characterization, classification, qualification, renvoi, remission, transmission, double renvoi, foreign law as fact, Section 45 IEA, Section 39 BSA, arbitration, recognition and enforcement, public policy exception, foreign legal persons, corporate capacity, complete private international law framework. And that concludes Stage 4, Teaching Mode, for Modules 3 and 4, the point where Hermione has now filled several blackboards, drawn at least 3 flowcharts, cited Latin terminology nobody asked for, and somehow turned a syllabus on conflict of laws into one giant detective story about identity, jurisdiction, and competing legal systems.